For Chris Hipkins.
Thank you, Mr. Speaker. My question is to the Minister of Education and asks, is she satisfied that she is fulfilling all of her legal obligations under the Education Act 1989? If so, why?
Honourable Hipkins.
Thank you, Mr. Speaker. Yes, because I'm working hard to raise achievement for 5 out of 5 kids.
Supplementary question, Chris Hipkins.
Thank you, Mr. Speaker. Did she ensure that all available information informing her proposal to merge Phillipstown School and Woolston School was provided to the schools when the consultation period required under the Education Act began? If not, why not?
Honourable Hipkins.
Mr. Speaker, as this judgment is still within the appeal period and one or other of the parties may appeal, it would not be in the public interest for me to comment.
Mr. Speaker.
Point of order. 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 This is a point of order and it will be heard in silence.
Point of order, Mr. Speaker. I didn't ask in any way about the case that was before the courts or the court's judgment. I asked her about a consultation process under the Education Act that she initiated and whether she felt that she had fulfilled her legal obligation.
I thought in the question the member asked that he referred to 2 schools being Phillipstown. Yes, well then that is the crux of the court case, so the Minister's answer is quite in order. Further supplementary?
Point of order, Mr. Speaker.
Point of order. Can I just clarify you're not in any way questioning the ruling I've just given?
No. I just have some clarification.
That's great.
Some clarification.
Let's hear the fresh point of order.
Yeah, no, the clarification is, Mr. Speaker, I didn't ask her about to comment on the court's ruling. I asked her about decisions that she had taken. Now, I'm not asking her to say whether she agrees with the court or not. I'm asking her whether she's satisfied with the decisions that she made prior to the court even considering the matter.
Yes, and I accept that the member's now raising exactly the same point of order again. And the Minister said that because it was involving those 2 schools, and that is the court case, the Minister, because it's still within an appeal time, does not feel it's within the public interest for her to further answer that. That is a satisfactory answer for the Minister to give.
Mr. Speaker.
I'll hear from the Right Honourable Winston Peters.
Because the Minister may or may not appeal this court case, the matter's not sub judice at all until she does. So, now that's the legal point, and the Minister, the Speaker should have regard to it.
I don't need assistance on that particular point, because the Minister didn't say it was sub judice. What she is saying is that there's a possibility of appeals by either party, and on that basis she does not feel it's in the public interest to further answer. That's a legitimate answer for the Minister to give. Further supplementary question, Chris Hipkins.
Were all of the schools proposed for merger or closure in Christchurch provided with detailed information on the likely cost of her proposals as against the retention of the status quo during the formal consultation period required under the Education Act? If not, why not?
Honourable Hipkins.
Mr. Speaker, as the matters the member is inquiring about are contained by the judgment and it is still within the appeal period, one or other of the parties may appeal. It would not be in the public interest for me to comment.
Point of order. Order. Point of order, Chris Hipkins.
Point of order, Mr. Speaker. Mr. Speaker, there were several dozen schools in Christchurch that were proposed for closure or merger. The court case that we've dealt with relates to only 2. My question related to all of those schools, and the Minister could at least, if she doesn't want to address the issue that may be possibly subject to court case, she could still address the rest of the schools proposed.
The Honourable Jerry Brownlee.
Mr. Speaker, this is a serious matter. It does involve the rights of a community to question decisions that are around this sort of activity. And it is also, Mr. Speaker, the right of the Minister to determine what is in the public interest when it comes to answering these things. And there shouldn't be anything said in this House that might prejudice either position. That's the position the Minister has taken, and that's perfectly reasonable in the circumstances.
Order. I'll hear from Grant Robertson.
Mr. Speaker, the question that my colleague asked was not one that actually engaged at all with the proceedings before the court. It asked a factual question about facts, seeking facts from the Minister. It didn't ask her opinion. It actually just asked her about a broader set. I wonder if you get my colleague to re-ask the question, Mr. Speaker, we might be able to take the matter forward from there.
In regards to the very first supplementary, I have no doubt that my decision was absolutely right. I accept the point that Chris Hipkins is making. This one was more general, At the end of the day, I'm not going to be responsible for the answer the Minister gives. She has said it's not in the public interest to answer it on a number of schools within the crisis, which frankly I find a surprising answer, but that is the answer given. I think the best way forward is I will allow the member an additional supplementary question for him to use.
Thank you, Mr. Speaker. Were all of the schools proposed for merger or closure in Christchurch other than Phillipstown School and Woolston School provided with detailed information on the likely cost of her proposals as against retention of the status quo during the formal consultation period required under the Education Act? If not, why not?
Honourable Hipkins.
Mr. Speaker, as the question relates to issues dealt with by the judgment, which is still, yes, they are, which is still within the appeal period.
Order.
And
I'm now having trouble actually hearing the answer. Could the Minister please repeat?
And as one or other of the parties may appeal, it would not be in the public interest for me to comment.
Point of order, Mr. Speaker.
Point of order, Chris Hipkins.
Mr. Speaker, my question specifically excluded the schools that have taken court action against the Minister's decision. It is not unreasonable to ask her to answer for her actions as required under the Education Act in relation to a matter that is not before the courts, has not been put before the courts, and as far as I know, no one is going to be putting before the courts.
To move the matter... Order. Order! To move the matter forward, I'm going to ask the member to ask the question again. I would hope that an informative answer could be given to the House.
Thank you, Mr. Speaker. Were all of the schools proposed for closure or merger in Christchurch other than Phillipstown School and Woolston School provided with detailed information on the likely cost of her proposals as against retention of the status quo during the formal consultation period required under the Education Act? If not, why not?
Honourable Hipkins.
Mr. Speaker, as the matters the member inquires about are relevant to the judgment, which is still within the appeal period, and one or other of the parties may appeal, it would not be in the public interest for me to comment.
Point of order. Grant Robertson.
Mr. Speaker, I presume that the Minister is using Standing Order 3831 in order to say that if the answer she's given can't be given consistent with the public interest. We are faced with an enormous difficulty on this side of the House if ministers are simply going to invoke that no matter what question is asked. Now, I know that you have taken the attitude that you've given the member an additional question in the hope that the Minister will answer. I do not find it acceptable under standing orders that you will now potentially move on from that. The Minister is obliged to give an answer that addresses the question. She can't simply invoke the public interest randomly. It has to actually relate to a specific case. This doesn't.
I thank the member for his point. I can only ask the Minister in answering the question to be informative to the House. At the end of the question, it is over to the Minister to decide how she answers the question, and if she decides to invoke public interest, that is where the matter lies. I cannot insist on a particular answer from a Minister. I would have hoped the answer would have been more informative. Point of order, Grant Robertson.
Mr. Speaker, while you cannot insist on a particular answer, it is your job under Standing Order 383 that the Minister addresses the question. Nobody's asking for a specific particular answer. My colleague asked a question which could be addressed in the public interest. He excluded the matters that you were concerned about earlier, and it is your job to require a Minister to address a question. The Minister has failed to do that.
No. I'll hear from the Honourable Jerry Brownlee.
Mr. Speaker, the member's question was a clever way of getting in exactly the same position and trying to put the Minister in a difficult position. Well, look, yes, he is one of your more talented members, no doubt about that. Mr. Speaker, however, if you go to Speaker's rulings 1725 right through to 1735 also, there is all of the rulings that the House has in front of it with regards to questions and answers. And it is very clear, sir, that the Minister has to make a decision about what is in the public interest. A Minister who is potentially engaged in further court action will often decide that it would not be fair to either party to progress the answer being sought by the opposition.
I thank the member. If I could refer back to Grant Robertson's point, where he correctly points out it's my job to see the minister addresses the question. In my opinion, the minister has addressed the question, certainly not to the satisfaction of the member asking the question, or indeed to Grant Robertson. The member has invoked an answer that says it's not in the public interest to answer it. I don't find that at all helpful to the House or informative. But the minister has addressed the question. I invite Chris Hipkins to continue his line of questioning.
Thank you, Mr Speaker. Is she satisfied that all of the schools in Christchurch in which she has made decisions to close or merge as a result of the formal consultation period, other than Phillipsdown School and Woolston School, were provided with all of the information they needed to have a meaningful say in the consultation process?
Honourable Hiki Parata.
Mr Speaker, as consultation was the subject of this judgment, which is still within the appeal period, and one or other of the parties may appeal, it would not be in the public interest for me to comment.
Supplementary question, Honourable Nanaia Mahuta.
Given her responsibility under the Education Act, is she satisfied that all the reporting obligations of the Te Kohanga Reo National Trust or any subsidiary entity have been met?
Honourable Hiki Parata.
Mr Speaker, no.
Supplementary question, the Honourable Nanaia Mahuta.
Subsequent to that answer, has she received any advice from ministry officials or her advisers regarding inappropriate spending associated with the Te Kohanga Reo National Trust? If so, what action will she take?
Honourable Hiki Parata.
Mr Speaker, no, but notwithstanding that, the action I have taken is to call an urgent meeting of the National Trust, which will be held this evening.
Supplementary.
Supplementary question, the Honourable Nanaia Mahuta.
Have any matters been brought to her attention regarding Te Pātaka Ohanga requiring her to investigate the use of public monies intended to achieve Māori language learning outcomes?
Honourable Hiki Parata.
Mr Speaker, I am aware of the allegations in respect of Te Pātaka Ohanga, and that is one of the reasons why I have requested an urgent meeting, and it will be held this evening.
Supplementary question, the Right Honourable Winston Peters.
When the Minister, in answer to so many supplementary questions, replied that it was not in the public interest, on what basis, to do with the standing orders or constitutionally or legally, was she making that statement?
Honourable Hiki Parata.
Mr Speaker, I'm making it constitutionally so that we would not breach the separation of powers between the judiciary and Parliament, and I was making it legally on the advice that...
Order. Point of order.
Speaker, no separation of power matters rise here.
Order.
The Minister's got required...
Order. 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 I don't need to hear it from the member. Would he please resume his seat? The member asked on what basis the member was giving those answers. The Minister gave a perfectly adequate answer to that. Point of order.
Mr Speaker,
right,
the Minister is required to be terse and to the point. And the point had to be with respect to the three issues put to her. Now, if there is no court case pending, or even contemplated to the best of my knowledge, how could she possibly answer the question that way?
By opening her mouth and giving the answer that she did. Order. Supplementary question. Order. Supplementary question, Chris Hipkins.
Thank you, Mr Speaker. Supplementary to the Minister. Does she stand by all of her school closure and merger decisions in Christchurch, other than her decision to merge Phillipsdown School and Woolston School? If not, why not?
Honourable
Mr Speaker, yes.
Point of order, Mr Speaker.
Order. Order. It is a point of order.
Point of order, Mr Speaker. If the Minister is able to answer that she stands by her decisions, why is she not able to answer questions on the reasons for that, which were what my earlier questions were?
Now, the member's been given an answer that he's satisfied on this time, so then going back on questioning earlier answers which the Minister gave. We've moved past that. I agreed with the member. I thought those answers were less than helpful to the House. They are the answers that have been given. Question number 5, Nikki Wagner.
Thank you, Mr Speaker. To the Minister